All right, good afternoon, everyone. Welcome to the Stringer LLP webinar arising out of the Ontario Labour Relations Board blockbuster decision in the Foodora case, which leads to the question is, in light of this decision, how is labour law in the province of Ontario and in Canada evolving to adapt to the potential unionization along with other employment law factors as it relates to the gig economy? I mean, certainly historically, in recent times have not been good for trade unions outside the public sector in construction in the province of Ontario. With the erosion of our manufacturing economy base has been the erosion of representation of unionized employees in that traditional sector. Unions have not been successful in general in terms of advancing into service economy employers such as big box stores and others. But is this sign of is this decision and this move towards Foodora towards unionization, although they're not unionized yet, a sign of the phoenix sort of rising from the ashes and trade unions making a comeback in the province of Ontario in the private sector, or is this just a one-off? The answer, well, we'll see. We'll give you some thoughts on that. We try to make sure we have enough time for questions, and this is a very interesting topic, so we encourage you to make this as interactive as possible as we sort of move into this new frontier. To ask a question, you type your question in the field box and just click send. It'll be added to the queue. If your question field is not expanded and you have the plus symbol, which you'll find on the top left of your screen, just push the plus symbol, sorry, top right of your screen, and just push it out. That will be there. If you cannot see, even that, you'll see at the top right of your screen an orange arrow, which is at the top of the icons. Just give that a push. That will open everything up to allow you to ask a question, which we, of course, encourage you to do. So let's start a little bit with who has the right to unionize. And what we're speaking with is under the Ontario Labour Relations Act, which covers approximately 90% of the Ontario economy. The Federal Canada Labour Code covers 10%. Of the economy, but for today's purposes, because this, of course, Foodora is, as most employers are, provincially regulated, we'll focus on it. The Canada Labour Code has some differences, but is relatively similar in many, but not all respects. So who has the right to unionize? Employees, but not people who are managers, and a list of other sort of exceptions. And you can see this, when you look at the list here, you can just sort of get a sense as to how old this legislation is, remembering that the Labour Relations Act originally was molded out of the Wagner model out of the United States from the Great Depression era, and the basic framework has remained relatively the same. So on that front, there is exemptions, but most employees, essentially people who aren't supervisors and those other exceptions on that list, are exempt from unionization. The next we wanted to get to is Union Applications 101, and this is how this generally works in the province of Ontario, is that unions file secret membership evidence with applications for people they say are in the bargaining unit. The bargaining unit being the group of employees in particular positions in a particular location that the union is seeking to represent. Employers file lists of employees. Often the employer provides a separate list of people who are working as independent contractors or employees of another employer. In order to get a vote, unions have to get a vote in the province of Ontario. They need to demonstrate 40% support of a bargaining unit. In construction, it's somewhat different in the sense they don't actually have to have a formal vote, but if the union has 55% of those sign union cards, membership evidence as it's referred to, then certification can take place. Outside of construction, Ontario has what's known as a quick ballot system. Within 5 days of the application, the vote is typically held, and 50% plus one determines the winner.
So some of the common legal disputes that will arise in these sorts of applications will be things like the scope of the bargaining unit. So the bargaining unit is sort of that defines that description of who's in for the count. Which employees will be subject to the bargaining rights and the certificate the union is after, and therefore covered by the union and ultimately a collective agreement when one is negotiated. The next is the identity of the employer. So sometimes there'll be an issue if there are multiple employers on one site. Who is the employer for purposes of the application? And so the union will put the name of the employer that they think should be on the certificate with their application, but sometimes the respondent will say, well, I'm not the employer of all of the employees. Here are 3 other companies that were employing people on this job site. And that happens in everything from construction applications to applications where you have a site with temporary agency workers and things like that. Another key issue will be employee status disputes. So outside of construction, which we're not going to get into in too much detail because it's quite complex and distinguished, outside of construction in most applications, a status dispute will be about who is actually in that bargaining unit as described in the first bullet. So if you're going to have in a hotel, for example, all the staff of the business except for your front of house and your health club personnel, and you're going to exclude people who are managers and above, for example, then those are the people, back office staff and those above, then everybody who wasn't excluded is in for the count. And then the question is, well, okay, who's actually in that group? Another issue will be who's actually at work on the day that the union filed the application. And if someone would normally be in that bargaining unit description, but they weren't there the day the union filed the application, the question is there a reasonable likelihood that that person is going to return to work in the foreseeable future? And again, construction is very different. We're not going to get into that, but outside of construction, you have to look for a nexus, a connection, a likelihood that that person is going to return.
Certainly, and one of the terms that is, I think, essential when we're talking about the evolution of the law in this area, and then you can see from the slides here, we're sort of going back into the right after World War II history books, back at a time when final appeals of Canadian court decisions were actually heard in London at the Judicial Committee of the Privy Council, to the well-known employment law case of Montreal v. Montreal Locomotive Works that basically established the initial test of what is an independent contractor, and most of us are familiar with the independent contractor analysis that really historically on that side hasn't changed all that much. It really is the difference between between an employee and an independent contractor really involves such things. Is the person really actually an employee in all but name only? Is there actually a risk of profit or loss? How much control the employee has? That sort of thing. In the Ontario Labour Relations Act was amended in 1975 to include the dependent contractor definition in employee to get around some of the structures which historically had made it a barrier for finding an entity as an employee, particularly say ownership of tools, for example. Ultimately, and then there was a decision of the Supreme Court of Canada in Yellow Cab Limited v. Alberta Industrial Relations Board, which basically set out the concept that someone is not a dependent contractor because they're not being paid wages, because of a very strict definition that was being led. However, of course, that analysis, not surprisingly, didn't last all that long, and Jeremy will take you into that case in a moment. But moving to the more recent case law, this is the decision of the Supreme Court in Sagas Industries. This sets out what is the test. This is repeated in almost every case in Canada where there's a dispute between whether someone is an employee or an independent contractor for employment law purposes. And the question is really, is the person engaged in their own business? However, the other factors that are always considered, does the person supply their own equipment? Does the person actually have any employees of their own? Is there any actual financial risk? Is there actually a risk of profit or loss, or someone just getting a fixed wage? Is there what type of investment? What type of management? Does the person engage in any marketing? Do they work solely for one person? Do they work for multiple entities, which is often an important factor? But I'm not going to read the whole document to you, but that's essentially what the test is. And moving to Ontario, both at common law and under the Labour Relations Act, the focus is really not so much is this really look like a relationship that's that of a master servant as opposed to that of an independent contractor. And the classic example is a truck driver who may very well own his own truck, be personally insured, paying for that own truck independently, but works exclusively for one trucking firm. Under the control of that trucking firm. Really at the end of the day, what often is found in those kind of cases is no matter how you dress it up, that's really an employee-employer relationship. So I'm going to move it over to Jeremy. He'll talk to you a little bit about the veterans taxi decision.
Right. So this is sort of where the rubber hit the road early on after the 1975 the Labour Relations Act, which imported the concept of a dependent contractor into the Labour Relations Act definition of employee. And so as Ryan said, in that 1980 case that came out of Alberta, we have the definition in the Alberta statute not including a dependent contractor category in the definition of employee, and it defined an employee to exhaustively mean someone who receives wages. And of course, someone who is an independent contractor but arguably could be dependent isn't receiving wages. So even though they may be very much like an employee in all other ways, the fact that they weren't getting wages was enough under the Alberta statute at the time, under the Supreme Court interpretation, to prevent them from being included in the definition of employee, even if they were considered a dependent contractor. And so again, the courts and the arbitrators and the tribunals have determined over many, many decades that there is a middle ground between an employee and an independent contractor, and that is someone who is still an independent contractor in form, but in substance, in reality on the ground, that person is essentially under the control and helping with the business of the alleged employer. So in Niagara Veteran Taxi, again, one of the earliest cases that came out after the change to our Labor Relations Act here in Ontario, the tribunal, the Labor Relations Board said, clearly a person need not be under an employment contract. Well, that makes sense because you're not an employee, you're a dependent contractor. But very importantly, they took away that requirement to have tools, vehicles, equipment, and machinery being major considerations as to the difference between whether someone is or is not going to be considered an employee for purposes of labor relations. The form of the contract, the form of the organization of the relationship was no longer going to be the critical consideration, and instead we're going to focus on business factors, entrepreneurial opportunities, investment, control over the manner of doing business. That's going to be the new way that we are going to, post-1975, look at this question. And so in Niagara Veteran Taxi, and I'll take you through this in a moment, they go through some of those factors, and ultimately, as I'll explain, they do make the finding in that case that these individuals were dependent contractors and so could be unionized. So here are some of the common indicators that someone is an independent contractor. And these flow directly from that 1964 case of the JCPC out of London. So what we've got here is the ability to negotiate over your price, your terms, a variance in fees, understanding that ordinarily when someone's in business for themselves and you're in a commercial relationship, there's going to be competition with other businesses for your account. And that means that they have to be able to compete against each other, and there should be evidence that they're able to adjust their profit, their loss, their investment in order to demonstrate entrepreneurial activity. Another factor is the control over where they work, how they work, the assignments and schedules, the right to bid on work they don't want or not, or not. The ownership and maintenance over tools of the business, that's still going to be a factor, though not as emphasized in the jurisprudence. The lower the degree of integration with the business, so if you're a retail store and you hire an electrician to come in and fix the lights in your business, you're not in the business of providing lights in your business, you're in the business of selling your goods. So that individual is more likely to be an independent contractor simply because they're not integrated into your business, providing your goods, your services at large. Also, the ability to be non-exclusive and to be promoting and advertising your own business is an indication that you are indeed in business for yourself. Reliance on the labor of others, as Ryan said, if you have a group of employees working for you, you're more likely an arm's length business that has a chance of profit or risk of loss, and you're running your own HR. Whereas if you don't have that ability, of course, the opposite is true. And finally, a chance of profit and risk of loss, and this is key. This goes back to the need to have real evidence of entrepreneurial activity. And the Labor Board has said over and over again, if the chance of profit and the risk of loss is essentially boiled down to the host, whether that be an employer or an alleged employer, telling you which hours you can work and you asking for more hours or less hours, if that's your chance of profit and risk of loss, then you're not really talking about an entrepreneurial relationship. And that's why in virtually every case I've ever read, and I believe that maybe all of them on this particular topic, where someone is being retained as an alleged temporary employment agency employee or as a subcontractor, but they're being paid on the basis of time, by the number of hours they're permitted to work by the alleged employer, they're almost in every case, as far as I'm concerned, I understand it to be every case, but I could be wrong, found to be a dependent contractor, if not flat out an employee. So let's look at some of the precedents that have that really touch on the Foodora example and the gig economy, sort of the couriers and service delivery drivers and such. So one of the earlier cases, only 2 years after the 1975 revision to the Ontario Act, we have in Canada Cut Crushed Stone a delivery driver who owned 10 of his own trucks. And he had employees who were driving those trucks on his behalf, and he ran them himself, he paid them himself, and he was paid by Canada Crushed Stone to deliver their stone to various projects around the province. So that individual was found to be independent. And so in that case, although the trucks might have said Canada Crushed Stone on them and he was only working for them, the fact that he had 10 employees working for him and was running essentially his own business under the banner Canada Crushed Stone printed on the side of the truck, he was an independent contractor, not even a dependent contractor. Now, another case which I just discussed, of course, Niagara Veteran Taxi. So this is a case where these taxi owner-operators were able to hire replacement drivers while they were on leave or vacation, and they did have a say in taking fares or not, and they did also have the ability to take flagged fares, like so the taxi driving down the road can accept a fare from somebody who hails them. But ultimately what the board found in this case was that the vast majority of the control in this relationship, all of the goodwill, all of the quality standards, the ability to hire a replacement driver had to be approved, all of those sort of factors about your ability to set price, collect on your own business, these things were all factors controlled by Niagara Veteran Taxi, and as a result, these individuals were found to be dependent contractors. Now, interestingly, I've gone through it, and I've also read a number of decisions which sort of hash this out, and there are no cases. There are no cases where there's a broker-dispatcher relationship, where the broker-dispatcher is of a company that owns a brand, and they have goodwill and they advertise. But the limo driver, or the owner-operator, was found by the board to be dependent, where that relationship between the driver and the dispatch company, they derived less than 50% of their income. So that the amount of income that you derive from your business, if it is significantly from that broker-dispatcher brand company for which you're providing these services or under their banner, then you're very likely to be found to be a dependent contractor, and the opposite is true. So we have a case here in 2013, Aeroport, which was a series of basically limo drivers at the GTAA airport, and the broker dispatcher had the ability to send them work, but these guys could also line up at the airport, and that was a significant, according to the board, a significant proportion of their income was derived from essentially standing at a taxi stand and from other sources of revenue. So they weren't as economically dependent on the dispatcher-broker relationship for their income. So then we have the case of Uber, and so in Uber, this is still going on, this case, but essentially a group of Uber Black and Uber Black SUV drivers who are all either separately licensed or registered as limousine drivers by the City of Toronto. And importantly, this does not include any of the other types of drivers, just the ones who are driving Uber Black and Uber Black SUV. And so the union filed an application to represent this group. There was a vote held in January of this year. The box was sealed because they're going to have a fight now about who's in and who's out. And so we don't know what's going to happen there, but I would imagine that the decision that we just had in Foodora, which I'll talk about in a moment, will have some bearing. But of course, as the board held in the Foodora decision, the facts are going to determine the result. And the facts are different in every case. And I think what I've done here in the Foodora slide, just to take you to this case, of course, this was just a couple of days ago. This decision was released by the board, which is why you're all here today. I want to take you through the 6 factors that we went over, which are indicia of independence. And so, as you can see, I've crossed off just about all 6 of what are the indicators of independence. So what we have here is a situation where the drivers for Foodora did not have the ability to negotiate the price. Instead, their onboarding was essentially filing an application online, having some vetting of their whether they have the tools of the trade and the safety gear, going through an instructional training video or reading an FAQ, and having a little bit of confirmation from Foodora. The wages were set, their territories were set, they were scheduled and given shifts. If they wanted to trade shifts, they had to swap that with approval of the dispatcher. If they wanted to change areas, they needed approval. If they wanted to go on break, they could do it whenever they wanted, but they were technically still considered on shift until the dispatcher confirmed it, that they were on break, and so stopped sending them referrals for work. If they, very importantly, if we had situations where the control over those assignments then was governed by their rankings, and there's even a sort of a pseudo-disciplinary process in place where they were given things called strikes of varying levels of severity based on violations of the quality of service expectations and other. And that would govern whether they got priority shifts, whether they got the less than preferential shift options, when they got options to choose their shifts. And ultimately, the app, the algorithm, and the dispatcher governed this relationship. The amount of money that they could charge was set by app, and only in very unique circumstances, and even then only with approval of dispatch, could they charge a sort of penalty fee if something that the restaurant had done has caused them to be delayed. Or, for example, if their route was blocked by a parade, then they might be able to get an additional fee tacked on to their kilometer rate, but the amount of that rate and whether they would get an increase at all, still subject to the determination by the dispatcher. Now, interestingly, they were given a $16 an hour guaranteed wage, and I wonder if that was done because of fears that they may ultimately be determined to be an employee, and of course we want to ensure there are minimum wage guarantees to avoid violating the act. And Ryan will talk a little bit about class action concerns when we get to that section, but that was, I think, something that I found quite interesting. Another aspect that I also found very interesting were the issues of integration and exclusivity. So there was some discussion, and I'll talk about it in a moment, about something called double apping, which is where they might be driving for Lyft and Uber Eats, Skip the Dishes, all the others that are sort of in competition or collaterally in competition with Foodora couriers. And it was only in the spring of 2019 that Foodora opened it up and allowed these folks to do it. And I'll talk a little bit about what that might mean. But ultimately, there wasn't enough evidence presented to the board that these guys were deriving significant income beyond that sort of 50% threshold, as we talked about in the earlier cases, to find that they were not economically dependent on Foodora. They had no chance of profit, no risk of loss beyond not being able to work or not getting the shift that they wanted. They were entirely dependent, according to the evidence the board heard, on the dispatchers for not only the rate, but the extras and for the orders that they got, and had zero control over that. Also, they were prohibited in part because practically it might be difficult, but also just in practice, they were unable to let their work to someone else. So they couldn't have a team of drivers delivering multiple orders on their behalf, that the app, the structure, the framework does not allow for it. So the board essentially found the ownership and control of the app and the control exerted through the app on the typical trappings of the employment relationship, along with the structure, the control over hours, the control over remuneration, the absence of entrepreneurial activity, all pointed toward these individuals being much more like an independent, much more like an employee than an independent contractor. And as a result, the board did hold that these are dependent contractors. So again, it's not finding that they are employees, it's finding that they are dependent contractors, which under our Labor Relations Act is included in the definition of employees who can seek certification, or unions can seek certification on their behalf. Now, again, I want to just touch back to that double apping piece because I found that very interesting. If you remember back to the airport case I discussed with the limo drivers who were found to have derived a significant amount of income from the taxi stand or the limo stand and from other sources of revenue, there was evidence put before the board about the degree and division of their various revenue streams, and the board found that this evidence that they were, they had these secondary means of generating significant income and other entrepreneurial activities showed that they were in business for themselves because they weren't as economically dependent. That was the fundamental factor in that airport limo case. So here we have in Foodora, and I mean, I wasn't there. I don't like to second guess litigation from an armchair, but there was an agreement by the parties to utilize what are called representative witnesses. And so what happened was the parties agreed that they would just take a handful of Foodora couriers, and the facts that those guys testified applied to them would be used sort of as a blanket to apply to all employees on the assumption that everybody's probably similarly situated. Now, I'm not sure why, as an employer, you would agree to do that. There might have been pressure from the board at a case management hearing for them to agree to that in their agreed statement of facts. But, I mean, ultimately, if you contrast the Aeroport 2013 decision with the double apping aspect of the Foodora decision, what you see is the board found that although there were some witnesses of the representative witnesses who said that they had double apped since the spring of 2019, there wasn't really any evidence of what proportion of their revenue was derived therefrom. And there also really was not an effort to determine how many of the drivers are double apping or triple apping or quadruple apping with all the other services that are out there. So if I were an employer's counsel on this particular file, I think I would be hard pressed to have agreed to representative witnesses unless either I was pushed into it and we had no choice because the board just ruled that that's how it was going to go.
Or the evidence is just plain against you.
Or the evidence is plain against you and you just don't know what you're going to get.
Yeah, you've got this double lapping as a new thing and no one's doing it, so it's not going to come close to 50%.
Well, exactly.
That's my suspicion of what the reality was, but of course we don't know that.
We don't know. I mean, ultimately, one thinks that the union sort of chose the perfect time. Having only opened up the floodgates to double lapping in the spring of 2019, there may not have been a significant number of couriers who had yet, found a way, not secretly anymore, to start double lapping and growing their entrepreneurial
and perhaps
activity.
They might not have been encouraged by the union to do that either.
Well, that's it. So, I mean, as a result of Foodora, one thing is very important. First of all, Foodora has not been unionized. Of course, the union application will now continue on the basis that the drivers can unionize. They will, the vote will have been taken and sealed, and they're now going to have fights about those issues we talked about. Who are the employees in the bargaining unit and all the other sort of pieces. One thing that I was just thinking about down the road, though, is what happens if the union is successful? So they win the right to bargain, they want to bargain a collective agreement, and then Foodora continues to take sort of an aggressive approach and says no to a number of the union's demands. Typically what unions can do is they can strike, they can seek first contract arbitration, and I wonder what the basis for that's going to be in this case. For example, how does someone in the gig economy picket? Where would you picket? Would you just sort of have to find a secret way to travel around and look for Foodora drivers? I'm not sure how you do that, except for maybe outside of the offices of the corporation itself, if they have any.
I mean, I think that it'll relaunch back into the old debates we haven't heard a lot about, way back to the old Pepsi case on secondary picketing. That's,
well, that'll be interesting, but I wonder if they're allowed to picket on my front lawn, Ryan. I guess we'll see. If the Foodora driver is delivering my lunch to me.
Well, a secondary picketing has to be the only answer to that, I think.
I think so. But I think we're going to see some interesting, constitutional issues and challenges come up as a result of this.
All right, so we're going to shift gears, if we can, to talk a little bit about some of the other areas of law beyond strictly the Labor Relations Act implications of these things, because I think it's crystal clear that the gig economy could potentially change all aspects of employment law. Just quickly, from an immigration law perspective, it is a routine practice for gig economy employers to ask for proof of work, the right to work in Canada, and either a work permit or a SIN card and all those kind of things. And one might think that that would be a very helpful argument to the union as to why these folks are employees as opposed to being independent contractors. I don't know about you, but when I hire a contractor, I'm generally not asking for a work permit. But the reality is, however, that the definition of work is so broad under immigration law that, I mean, it can even include an unpaid intern that gets very broadly defined. It bears no relationship at all to the common law definition of master or servant. I mean, unpaid interns, as I said, could be considered an employee for immigration law purposes. So this factor of a work permit, I don't think, will play a significant role in these cases. Undoubtedly, the unions will rely upon it, but again, I don't see it as a significant issue. But it is kind of an interesting little nuance to how that works. Moving on is the Employment Standards Act, which, as we discussed earlier, does not recognize this concept of dependent contractors. So it follows the more sort of strict test for things like ownership of tools, which is often an important analysis in cases dealing with the gig economy, given that at least at this point in time, so much of the gig economy involves transportation of one kind or another, be it people or goods and such. So, and of course, and so certainly that's an important issue. Also, I should point out that the ESA includes numerous exemptions and special rules created by regulation that will be relevant to many gig economy employers. I mean, certainly taxi drivers have a number of exemptions under the regulations to different important overtime and such. And if you look at, is an Uber driver a taxi driver? Well, I mean, pith and substance, one would say they're essentially doing the same thing, but obviously there's any number of differences between, depending upon what the arrangement is for an individual. A taxi driver can be anything from one of 100 guys working for a brokerage to an independent contractor in certain, legitimately one-off in certain jurisdictions. So it'll be interesting to see. The most important litigation in this area is one I think some of you who follow this are probably familiar with, a case called Uber versus Heller. This was a case which is a class action, and we certainly have become used to very expensive class actions in the area of employment standards, often against the banks, for example, where there was a number of claims brought for unpaid overtime, where essentially the banks had contended that certain employees weren't entitled to overtime because of the managerial exemption that exists in most employment standard statutes, and certainly and the claim of the claimants was, well, we're not really managers of anything, you're just avoiding paying us overtime. And lots of settlements were made. And Uber basically, Heller was the representative, the proposed representative plaintiff, the person in whose name the case was brought. And basically the Uber drivers sought two things. They first of all sought a declaration that the drivers are employees under the ESA, which is going to be a harder test for them to meet than under the Labor Relations Act, ironically. And they argue that they are entitled to significant damages for various things that happened. And Uber had every employee sign a standard form onboarding agreement, which is very typical in the gig economy. In almost every gig economy case, any proposed partner, as they're sometimes called, a contractor or employee from a union or labor side perspective, has to sign a contract that includes a number of provisions. And one that was interesting in the Uber provision was that it required that if there were any disputes, that the drivers arbitrate these disputes, not in Toronto, not even in the United States, but in Uber's home base of the Netherlands. And the notion was, and the argument was successfully, amazingly enough, made in the initial court proceeding to have the class action dismissed on the basis that the arbitration clause trumped the individual's right to bring a class action. That is the kind of jurisprudence, that kind of argument has been successful in the United States over and over again, to a point where it's made it exceptionally difficult for various types of class action, not just employment, but product related and others, because of these type of arbitration clauses that basically confine people to bring individual claims in front of decision makers with perhaps somewhat of a dubious rules that favor the company. The Ontario Court of Appeal last year overturned this decision, and there were two aspects to that. First, the Ontario Court of Appeal held that when one's considering dismissing a case at this stage, one has to assume the pleadings are true, and if the pleadings were, in the court's view, if the pleadings were true, then the forum selection clause was invalid because you can't contract out of the ESA. And then secondly, the court found that requiring Canadian drivers to litigate their case in the Netherlands was unconscionable. Unconscionability is a concept as old as the common law itself, and basically says that if a contract is ridiculously imbalanced, even on public policy grounds, someone may have signed it, but we're just as a matter of policy and a matter of fundamental fairness, we're not going to enforce it. And as much as I'm a management side labor lawyer, one can understand why a court would have a certain degree of sympathy that an individual driver based in Toronto, Canada, would be disinclined to litigate their case. But when they were forced to sign a standard form contract that forced them to litigate their case in Europe. I think it's the example of that type of aggressive hardball tactic, which may very well be legally effective in Ontario or elsewhere, is going to leave the impression for the courts, at least in this jurisdiction, in my view, to not be particularly sympathetic to the position advanced by Uber. Not surprisingly, Uber has appealed this decision to the Supreme Court of Canada, and ultimately, ultimately, it's my view that assuming that Uber's appeal is dismissed, and I think it will be, there is an astonishing number of interveners. Every labor organization and other employer groups have intervened here. certainly Uber's argument, that they're trying to say that if this appeal is not overturned, that it'll gut arbitration clauses in Canada. I think that might be, although some interesting lawyering, I'm not sure that that's going to get them anywhere. I would be quite surprised if the Supreme Court restored the original trial judgment, but that of course remains for the court. Has surprised us before and may surprise us again. But ultimately, assuming that Uber's appeal is dismissed, that's just the beginning of it. They then actually have to prove these people, the Uber drivers, actually are employees within the meaning of the ESA. And I think there are significant legal hurdles for them to do so. Certainly, you heard Jeremy's comments on Foodora. Uber certainly does permit their drivers to use other driving. I mean, their main competition in this city, Toronto, is Lyft, but there are others. And that fact that if you have someone really splitting multiple apps, there's a very attractive argument to be made that basically what Uber and its competition basically are is sort of a payment processing and referral service that you're allowed to use as many as you want, and you can strategically build those up. That could show a bit of entrepreneurship, particularly the more evidence there is that more drivers are using multiple apps, the better the case is for Uber. So the bottom line is that litigation could take years to resolve. Moving on to WSIB, the WSIB test historically traditionally follows the traditional Montreal Locomotive Saugus analysis. The board policy basically mirrors the criteria that comes from the common law, but basically the WSIB has taken the position that Uber and others of these food organizations, food delivery services and such, are employers of workers within the meaning of the Act. And ultimately, there has been no litigation on that. But I could tell you that in practice, even if one looks at the WSIB's test as being similar to the common law, in practice, the board has a much broader interpretation and does everything it can to sweep up anyone into Schedule 1 that it can. So ultimately, any gig employment service that's operating within this realm should be ready for the possibility of some litigation with the board if they choose to fight it. But of course, the reality is it may just simply be that the gig economy operators, they see a significant benefit to being a part of WSIB because it then takes away their partners or employees or subcontractors' right to sue them in personal injury if something arises, which may actually be valuable insurance depending on the actuarial calculations of that. Occupational health and safety law is absolutely straightforward. OHS law basically the definition of worker in an employer basically sweeps in independent contractors as workers. There's no debate about that. Court of Appeal decision in R.V. Wisson has established that decades ago. There is some litigation at the Court of Appeal now dealing with OHS and the definition of employer or counsel on that file, but that has to do with the interaction of a construction project. It has nothing to do with altering the Wisson definition in our view. So again, if gig employers in Ontario have extensive employer obligations, if there's injuries to one of these contractors, it is not a defense to say they're an independent contractor. So that is less than helpful. One thing I think that we forget when we get caught, lawyers do, that we get caught up in the minutiae of all this, is forgetting the fact that legislation could change all of this. Now, I'm going to suggest that the current Ontario government, under the current political stripe, is likely to do this. But we looked into, certainly through our work law network, we're part of a network of firms that are practicing labor law across North America, and we looked at California, which is, of course, where most of the big-time gig economy companies were founded in Silicon Valley, has proposed legislation that completely alters the traditional independent contractor test. Historically, the California test for an independent contractor was rather similar to ours. Now the new test that's been proposed by a state legislation is that the individual is free from the company's control, is doing work that isn't central to the company's business, and has an independent business in that industry. The practical effect is, if one interprets that on the basis of the plain language of it, it means that basically everybody in the gig economy is going to become an employee. Bottom line, what the bill requires them to do is that means they have to start paying minimum wage and benefits and paid sick days and all those things. As you can imagine, this has not been very popular within the gig economy business, and there's court challenges and political lobbying galore in a state that's dominated at all levels, like both the executive and legislatively, by the Democratic Party, which is rather left-wing in California. So it'll be interesting to see what happens. I will say it's been interesting. It's become so broad, though, that legislation has swept up people that really historically had been operating quite fine and dandy for years, i.e. freelance writers are now finding themselves, guess what, you're an employee now, whether you want to be one or not, because of this rather aggressive response. So you can certainly assume that unions and worker advocates are going to be pushing here in Ontario for this sort of California approach to things. Well, whether it actually happens, of course, remains to be seen. Not likely anytime soon in this province.
So let's take this down to where the rubber hits the road from a labor perspective. I mean, obviously Ryan's taking you through all the other areas here, and a lot of those will have a tangential effect. But remember that the fact that you're complying with one or more of those other regimes does not automatically mean that you are something different under the Labor Relations Act. So let's talk about what typically happens here. So you've got a company like Foodora that is trying to remain union free. You sort of have three ways to do this, right? You can have employees on purpose, you can have independent contractors and treat them as such, or you can try to work with some sort of a hybrid and see what happens, okay? And I guess what we need to keep in mind is not only the legal test, but the practical union avoidance strategies, I think, are something that we really need to consider. So when we act for employers, which we do all the time to help them with sort of union avoidance planning and dealing with that organizing drive when it happens, or responding to an application for certification when it unfortunately arrives, what we're doing is we're looking for ways to convince the people, either before an application or once one is filed, not to support the union. So how do you tell people that you have zero relationship with on purpose, who you've been treating quite shabbily for a very long time, and forcing them to arbitrate their agreement with you in the Netherlands or somewhere? How can you convince folks like that when the union comes knocking that they shouldn't open the door? And I think that's a significant issue, right? It is, you want to think about, do you want to win the hearts and the minds of these people? And so if you don't think you can, because your business model doesn't permit you to treat them with a whole bunch of bells and whistles to make that case,
or you have a good faith belief that your business truly is that of an independent contractor, and the kind of people you're trying to attract are attracted to that model, you have to stick with that model.
And so those are the two issues, right? So if you decide that you're going to treat them as an independent contractor, and you want to make sure that model is upheld, then we have to talk about the things that we learned from the Foodora decision and the other ones before it. But I don't want anyone on this call to forget that there is still another option here. And the other option is to actually not call them independent contractors, and to have a robust union avoidance campaign, and esprit de corps, as it were, dealing with other matters. We don't have time to talk completely about how that would work here, but I just want to flash that out there for consideration. So really, when it comes down to, if you've made the decision that the way you're going to avoid unions and other aspects of your business would be benefiting by having independent contractors, and you want to avoid unions, then we need to go back to the question, which comes from 1964 and really hasn't changed all that much. Whose business is it? So you want to think about the sorts of indicia of independence, and what have you done in the structuring of that relationship and the ongoing maintenance of that relationship to ensure these are entrepreneurs in business for themselves, taking risk, having a chance of profit, and really having some control over what their business is doing. So if you need to have standards, as any business with a flag and a brand needs to have, you want those built in as standards, and you want to have commercial methods for dealing with that. But you don't want to have those mirroring, as I think perhaps Foodora did in their strike-based system, something that looks a lot like progressive discipline. You want to permit, if you can, subcontracting and assignment of work. You want to ensure that people have the right to bid for work with you or take work with others without that having an impact on their business. Now, if someone agrees to do something for you, if you have a true commercial relationship, someone's agreed to be your contractor, and then they stiff you and don't show up, well, yeah, you might not hire them again, and that's fine in a commercial relationship. But you don't want to penalize someone for their decision not to bid in the first place. That makes it look a lot more like this is an employee that you've expected to come to work tomorrow, and they didn't show up. Another aspect that I think everyone needs to keep in mind is really it's that entrepreneurial opportunity. It's that those factors about the income dependence are the most important aspects. So you have control, but sometimes control can be about quality standards. Sometimes control can simply be about the market and when people happen to be asking for goods and services. So those factors, while important in my view, are often, especially in the gig economy, going to be outstripped by questions about that entrepreneurial activity and that true economic dependence. To what extent are they dependent on you to earn a living? To what extent are you controlling their business's ability to make investment, to take risk, and to earn profit? So just some things I thought of, and I was just sort of brainstorming, Ryan and I, about things that a gig economy type business could do to encourage that entrepreneurial spirit.
And some of this stuff has taken place in California already in response to that bill. Some of these things that Jeremy is talking about, certainly Uber has made some changes to the app to try to, at least in that particular jurisdiction, to try to increase the suggestion that it's a truly independent entity.
Well, and that's it. So, I mean, obviously, the decision to allow double apping, which is something that Uber and Lyft and those of that ilk have been doing for a very long time, is an important thing to allow them to not be exclusively tied to you and to build that roster of market opportunity.
But it's also a very market-driven exercise, though. I mean, because certainly you can. I would imagine that Uber versus Lyft is the split of the market may be very different depending on how many people actually have the app, which of course the drivers have no control over. So you have a market where Uber controls 80% of it. That's a tough fight.
It is, and certainly that on its own is unlikely to be sufficient unless there are other avenues of generating income. But we look at that, we can look at other options of allowing those individual businesses, all of those independent contractors, to make decisions about their business. Perhaps there's a fee that drivers get paid as a flat fee when they show up, and on Tuesday, one driver decides he's going to waive that fee for all of his customers. Does he have the right to do that? And would that be something that the end customer can see in order to choose him as their driver, therefore allowing him to effectively market his own business? Do you allow people to have their favorites, a driver or a courier who's done a good job, and you can name hire them? Now, is that something you want to allow? That's a much broader question that I'm not here to answer, but allowing individuals to hang up a shingle as a courier, as a driver, and to really market themselves and take on risk and make investment decisions into their own business. Those are the sorts of things and opportunities that we want to be generating. But ultimately, if you're going to exert the sort of control that we saw in the Foodora case, all of that may not be sufficient, but time will tell. Right?
I guess my final comment is just sort of like, again, the labor side is certainly the practical side. This isn't like organizing a factory. It's not even like organizing a small taxi brokerage that has X number of people who are the core regular drivers on any particular day. I mean, we're talking about there's going to be a ton of litigation over who actually gets to vote. And we have to remember, I mean, we keep going back to the drivers, but that's what many of these entities are. Ultimately, who gets a vote? Like places like Uber, you can drive for a few hours a week and maybe come back a month or two later. There's going to be all kinds of litigation on that. And also, the unions, it's also going to be 21st century organizing techniques. They're certainly out there on Reddit and other social media. There are gatherings of drivers of these various, from these various companies talking and saying what's good and what's bad. And it's certainly a 21st century organizing tool that can be used by union organizers to try to, push their case and to push their propaganda on people. So it becomes a real, it becomes a real balance on those kind of issues. So a lot of things remain to be seen. So I think where I just really want to close out is to say that, look, these are early days, and we are also dealing with a couple of very significant players that are well funded, that have shown by their very nature many of these gig economy companies, and Airbnb is perhaps is not so much an employee-driven thing, but Uber and others have been disruptors, right? They've come into areas that have been subject to historically strict licensing and pricing. Most jurisdictions required a taxi to be licensed, charged a fixed amount of fees, capped the number of licenses that there were, imposed certain standards. Uber first walked into many of these markets and ignored all those things. Airbnb, same type of thing. And ultimately, as they ultimately did in most circumstances, become sort of legitimately recognized and insured and all those things. But what it shows is they're well funded. There's going to be a lot and long time of litigation unless there's a legislative response before this really becomes clear. So,
sure, and I guess to one of the things Ryan said there about the litigation will likely in all these cases involve who's in for the count. You know, how often do you have to drive? Is it enough to just have the app on your phone and that makes you a bargaining unit member? I think those are going to be some interesting questions that will have to be litigated as we go forward. And I'm looking forward to some of those fights myself. I don't know about you, Ryan.
Yeah, no, there's certainly, from a legal perspective, certainly one of the more interesting labor relations developments which have occurred for some time. But it will, and I ultimately would be quite surprised at some point if there isn't some sort of dealing with this at a legislative level. But one must never forget, and Jeremy, I think, and I would maybe ask you to comment on this. The Labor Board has in the past dealt with sort of these itinerant kind of employees in taxi brokerages, truck drivers, construction industry. They've developed their own sort of common law tests on how to deal with it. Is that right?
Yeah, that's true. So for those of you who have any experience in the construction industry, you'll be aware that not only do we have card check certification, whereas Ryan explained they can have, if they have more than 55% membership evidence of the bargaining unit when they file their application, there is no vote, they just get certified. They also have a day of application test, which the board developed on its own. It's not in the statute. And what the board essentially found 30 years ago was that these employees, or 40 years ago, was that these employees, their employment is so fluid. They tend to go from one employer to another. They're laid off. They're rehired all over the place. That it wouldn't make sense to use sort of the list of who's working on the day the application gets filed. So instead, what they do is they only look at who's working on that day in the bargaining unit, period. So the day the union files an application. And that's a test that was developed by the board. The board has developed that test in, to my knowledge, only one other sector of the economy, which is the entertainment sector, dealing with technicians who work at, the Sony Center or something like that. And so it could happen, to Ryan's point, the board could find, in response to the defense that Foodora may very well raise about who's in for the count, everybody who has the app or only people who have worked on the day or within a certain period of time before or after, the board might say, you know what, we have no idea how to determine this question. We're going to have to create a new test. And maybe they'll use a day of application test, or maybe they'll use something else. But I'm not quite sure how the board is going to deal with that question of the itinerant employee in the gig economy. That's a very interesting legal issue to discuss.
It is, and if the day of employment test is introduced, that is a very union-friendly development. So they have to get over the hurdle of being workers, and once they do that, that's a very union-friendly development.
Yeah, I mean, I think the only way that might not happen in this area as opposed to construction is in construction, the union has very simple ways to determine who would be in for the count, right? They just they have a bunch of salts. They find out who's out in the field working on job sites. They take a bunch of pictures and then they file their application when they know that they have the numbers.
It won't be as easy as it is in construction.
It won't be as easy to know who would be in for the count when everybody has a cell phone and they're driving around.
We have one question, Jeremy.
Yeah, so just please do send in your questions at this point. Other than will the slides be sent out? The answer is yes. We do have a question here, which is the implications for Foodora for the long-time compromise or acceptance of owner-operator truckers who may or may not own their own trucks. Let's see. So I'm not sure if I completely understand that question, Ryan. Do you?
Well, I mean, I think that ultimately, I'm not sure I fully follow it either, but I think that that really ultimately, if they start getting into people that don't own their own trucks, I guess that depends on who owns them.
Well, yeah. So I mean, just to go back to delivery drivers and owning of your own trucks, there are many cases going back to Dominion Dairies in the 80s. And the crushed stone case that we covered, but those are just a couple of examples. The fact that someone owns their own truck is not going to be sufficient for them to be found not to be a dependent contractor. And even even contractors who not only own their own truck but also employ their own helpers from time to time have not been found to be independent contractors when the other factors of control and economic dependence are present. So when someone is essentially a driver for hire and they might have a helper in their truck who they pay some of their money to, that individual is very likely on the board's jurisprudence for the last really 30 years to be found to be a dependent contractor. Unlike in that initial case that I talked about, which comes from 1981, where that individual had 10 trucks and people actually driving them. So he was clearly running a business, whether or not he had other employees as well.
Sure. I mean, I think that ultimately what the analogous argument might be is that if, even if someone is leasing it from someone else, it's almost like a staffing agency argument in a way. And when it comes to staffing agencies, the board has repeatedly followed they vote as part of the bargaining.
Yeah, there have not been any cases to date where someone is sent in as a temporary agency worker, where they're not working for a clearly arm's length subcontractor, and instead they're being paid on the basis of hours and the number of hours and a set rate that gets negotiated with whoever the company that sends them is. They've always been found to be dependent contractors and employees for labor relations purposes. So another question we have here: how different is the Canadian Industrial Relations Board versus the Ontario Labor Relations Board in the issue of truckers? And I'll have to admit that I did not do a survey of the Canadian Industrial Relations Board jurisprudence on this issue. They do take a similar approach when it comes to the economic dependence aspect of this piece, but I have not done a survey of all jurisprudence, so I don't want to answer the question about whether, from a jurisprudence perspective, the CIRB has a different approach. I admit I would want to do a little bit more looking, and I can see who asked that question, and I'm happy to send out a note on that when we send out our request for survey replies.
Well, seeing no other questions, we'd like to thank everyone for your attention to this very interesting topic. We tried to pack as much as we could into the hour, and we thank you for your attention and on such short notice. This is an evolving area, and as the case law continues to develop, Jeremy and I will be back to update you on the developments, of course, in the Feburary case, along with the Supreme Court's decision in Heller and some of the other litigation that's ongoing. So on behalf of Jeremy Schwartz and the partners of Stringer LLP, and we wish you a good afternoon, and we'll see you on our next webinar.